The next argument is United Blower and GM McCrossin versus the Lycoming County Water and Sewer Authority. Representing the Sewer Authority is Mr. Austin White. Representing United Blower is Mr. Paul A. Logan. And representing GM McCrossin is Mr. Thomas O. Williams.
Good afternoon. This case presents an issue of first impression under the Pennsylvania Steel Products Procurement Act, which in pertinent part requires that contracts with public agencies utilize only steel products where at least 75% of the cost of the articles, materials, and supplies have been mined, produced, or manufactured in the United States. In this case, the Lycoming County Water and Sewer Authority appeals from the Commonwealth Court's order holding that the air blower system supplied to the authority by Applt's general contractor GM McCrossin and supplier United Blower Inc. did not violate the act based upon the determination that the foreign cost of the products did not exceed 25% of the total cost of the products. In contrast, the authority contends the hearing officer below correctly applied the act to conclude that the foreign cost exceeded the 25% limit. In addressing this issue, we are asked to construe the term cost under the Pennsylvania Steel Products Procurement Act. Mr. White represents the appellant. Please proceed.
Thank you. May it please the court. My name is Austin White of the McCormick Law Firm in Williamsport, Pennsylvania, and I'm arguing on behalf of the appellant, the Lycoming County Water and Sewer Authority. First off, I'd like to thank the court for reviewing this matter. It's specifically and it's incredibly important to my client. Guidance from this court on the Steel Act generally is monumentally important as well, not only to the authority, but to many municipal entities across the Commonwealth. And with that, I'm going to cut right to what it is that we're asking the court to do. And I'm going to try to summarize that in a single sentence. And that's that we're asking the court to hold that where both foreign and domestic steel is used in a product, the Steel Act requires a contractor to substantiate that 75% of the cost of the steel products are of U.S. origin. And that's a lot to unpack there, so I'm going to break it down into 4 parts as briefly as I can. So first off, this does involve a mixed steel products. This is not a case where the steel was purely USA sourced. So we do have the requirement to go through the 75% calculation. Second, as far as the contractor's burden to substantiate compliance, the contractor, like the contractor here, knows that compliance is required with this law. The contractor has the power to source the steel, to use all USA steel or a mix, and to secure documentation regarding the cost used. So if the contractor wants to sell to public agencies like the authority, like was the case here, they need to find either a way to use all U.S. steel or to use some other way to trace the source of the steel that they're using if it's coming from foreign sources, at least in part. And that's what happened here. We had competitive steel bids. This contractor, GM McCrossin, decided to submit a bid, and then they secured the subcontract through UBI. So third, the focus has to be on the 75% that makes up the domestic side of the equation, because the purpose of the Steel Act is to advance the United States steel industry. So when we count dollars paid to United States steel producers, we're tracking how much money the United States steel industry has benefited. And that's what the Act is intended to do. It's to focus on the economic prosperity of the domestic steel industry and it's not about prohibiting United foreign steel. The law doesn't say that no more than 25% shall be from foreign sources. It's couched in terms of how much should be from the domestic side, which is 75%. So every dollar associated with the domestic steel industry should go to the 75% side, and every dollar that isn't shouldn't. And the Commonwealth Court here allowed incidental costs for foreign steel domestically incurred to be on the 75% side. And we don't think that that's the correct way to look at the Act. And that leads to the fourth and final component, which is the cost calculation, which of course is what the court here has accepted in terms of the appeal. And that goes to the numerator and the denominator. So the Act is concerned with the ratio of the cost of domestic steel versus the cost of all steel. So it's our position that the numerator should be the cost of the domestic steel and the denominator all steel. And that's the only way we can firmly determine whether or not the 75% threshold is met. And now, as the court's aware, what transpired here was that the contractor admitted to the cost of the foreign component, and that was the $67,000. And then we have the total contract price, which, depending on which contract you look at, it's either $239,800 or $243,505. So all of the cost, other than the $67,340, is on the other side of the equation, and it includes all the labor, all the soft costs, engineering, materials of every nature. The UBI admitted it was rubber, cork, aluminum, steel, everything. So we asked for those numbers as far as what's on that other side so that we could figure out whether or not 75% could be met. And they said it was impossible. It was too difficult for them to calculate. So the hearing examiner resorted to what he was left with, which is an admission as to the amount of the total contract price that was purely attributable to foreign cost. And that last point goes to the problem with the other side's position that this is a close call, so to speak. It's not a close call based on what the Steel Act requires, which is 75% domestic relative to all the steel. They didn't provide documentation to that effect. They just admitted that amount that was attributable purely to foreign steel costs. There was nothing in the record that they could produce, and in fact, they said it was impossible in terms of providing that 75%. So it was never a close call, and that's one of the biggest issues that we're having. And the Commonwealth Court looked at it and phrased it in terms of the inverse way of proving compliance, which is, that's why we're in the situation that we're in, where they could claim that there should be deductions or rebates or things like that, because they never actually provided the 75% component of U.S. steel, which is what the Act requires. So those are the 4 points.
Justice Baer, whose burden of proof in this case?
Your Honor, the hearing examiner did address that and looked at it that the authority had an initial burden to prove that there was some reason to question that where the source of the steel came from that was provided by the contractor. And it said that we had met that burden, and at that point it turned over to the UBI and the contractor, McCrossin, to actually provide some evidence that substantiated that they complied with the Act. But in any event, all of the case came out on the authority's case in chief. All the evidence was presented. In our case. So even if the burden of proof was purely one on the authority, I think that we met that burden.
Well, where do you think the burden? And maybe it's not a close case, but in red car, blue car, who knows? The party with the burden loses. So if this is at the end of the day, when we're looking at it, you could flip a coin. Do you have a feeling? Do you have a position on burden of proof?
Your Honor, I think that the way that the hearing examiner did it was correct, because if we look at the Act, it says that a certification should be provided, and they did in fact provide the certification under penalty of perjury that said 75% of the cost was attributable to domestic sources. So when they provided that, and when the authority got the steel products that had made in China labels all over it, I think that we showed that there was a reason to question the certification, and at that point, I think the burden was now on them to provide documentation that substantiated compliance. So I think I would approach it as a burden shifting, and I think that the hearing examiner approached that correctly.
And may I ask you, as I prepared for the case, I thought there were two sub-issues as this case is developed. 8 or 11 blowers, were 3 free, or was it a unit cost? And then, as you did allude to, whether various components of the cost, which are arguably done on American soil, would not count against the foreign cost. Are those the two issues you want to argue, or do you see the case differently than that?
I think, Your Honor, I think that that's a good way to characterize it. I think there's three issues. One being the 75% compliance, to show that as an affirmative proof of 75% domestic. As Your Honor just referenced, the two other components being the free blowers. The way that those blowers came to be is it wasn't a gift. They weren't free. The way that the record came out and the way the hearing officer approached it was that this was a change order that was proposed by the contractor, and the authority would not allow the change order unless it included swapping out of the roots blowers, because the three that were taken out were roots blowers, and they would have been able to remain had the original contract specs been met, because it specified roots blowers. So you would have had all roots blowers, and you would have maintenance consistent across all of those blowers. But because McCrossan sought the change order to swap out the UBI, a condition of that change order included these additional blowers. And so then what the authority did was it purchased that whole package. Nothing was free. And in fact, McCrossan even got those roots blowers that were in the system taken, and what they did with them, whether they scrapped them or whatnot. I mean, there was an exchange there. So I think that I don't think that is an issue that the UBI and McCrossan can hang their hat on. And also the I'm sorry, the other issue that, as far as the other component, I'm trying to remember what the other issue, Your Honor, that you said.
Well, may I ask you this, Mr. White?
Yes.
I don't know if it's an issue or not, but what's the remedy for the violation of the statute? So
the remedy in the violation was, the statute says that and I'm just going to read it verbatim because it's, we do not have any case law or anything interpreting this section, but it says, any such payments made to any person by any public agency which should not have been made as a result of this section shall be recoverable directly from the subcontractor or contractor, subcontractor, manufacturer, supplier who did not comply with Section 4 by either such public agency or the Attorney General of Pennsylvania. So
when somebody gets a windfall, don't they, if you leave this stuff sitting there and they own it and it's intact and you're not going to disassemble it?
Well, I think that we looked at this as there is a stiff penalty, and the stiff penalty is just for the non-compliant products. It's not. This is one component of a larger project, a multi-million-dollar project. So it's not as if a whole project is going to be refunded. It is just the blowers, and for the $243,000, the hearing examiner said, look, the law says it's recoverable. That amount should be paid back because they didn't comply with the act. And I understand that sounds like a harsh penalty. And and UBI and McCrossan have said that's unfair because the authority has gotten the ability to use these blowers for as long as they've had it. But that's what the law says, and that's the only way I can read it. We've wrestled with this before, and the hearing examiner certainly wrestled with it to try and figure out what this means. And I can't see it meaning anything other than you get the payment back that you shouldn't have made. And the payments that should not have been made are those for these blowers, because the blowers cannot have payment for them if they don't comply with the act. So I think that's the only way we can read it.
Thank you.
I'm sorry. So the one, as I saw it, there were two issues. You sort of addressed one, although I don't know how much argument you made, which is, and I'm not even positive, being math challenged, the impact of it, but whether or not you bought 8 blowers and 3 were free, or whether you bought 11 blowers for the unit price. And then the second issue was, to the extent that there are costs incident to purchasing the blowers spent in the United States for shipping, for storage, for the like, whether or not that would be subtracted from the total cost of the blowers. I think those
Thank
are the
you.
two
Thank
issues
you, Your
that
Honor.
lead from your case.
I apologize. I'll start with the second one then, and then I'll try and go back to the first one again and try and provide a little bit more argument. So in terms of the incidental costs, as the court is aware, the 10% deduction, which is what the Commonwealth Court provided to UBI and McCrossin, and what the trial court provided, but the hearing officer didn't. The way that I've approached that, and the way that I think that the law reads, is that the law is intended to advance the steel industry, so the domestic steel industry. So the incidental costs of foreign steel do not advance the domestic steel industry because they relate to foreign steel. So a 10% importing, warehousing, let's talk, for instance, the Euros blowers coming from China or Asia, they came to the United States. That manufacturer in a letter said that 10% was domestically incurred, but it's domestically incurred related to a foreign steel product. And I don't think that would advance the purpose of the act, which is the economic prosperity of domestic steel. So under those circumstances, I don't think that you can attribute that to the other side of the equation.
I'm sorry. When the authority received an invoice from McCrossin or UBI, did it set forth those costs discreetly? Cost of blower, 200,000, cost of transportation, storage, whatever, packaging, 40-some thousand?
No, Your Honor, I think that it was the 243,505, and I don't think it broke any of it out. It was just that flat amount. We'd have to look at the payment applications is the way that all of it came through. But because McCrossin was the general contractor for the entire project, the way that they made payment applications wasn't just limited to this particular blower set. It was all over the place because it was a multi-million-dollar project.
All right, thank you. You want to comment any further at all on the other issue? I don't understand the math, but again, we have people that can figure this out. The mathematical ramifications of 8 plus 3 free or 11.
Your Honor, I think that the position that McCrossin and UBI have taken is that you shouldn't include those, So maybe I'll try and get to the mathematical part. So UBI had to purchase those blowers from the company that they got them from, the ones that they've characterized as free or a gift. And so there is a cost to UBI for those. UBI's invoice to McCrossin was the $239,000. And so when UBI had to purchase those, they had a flat cost to McCrossin, and McCrossin had a flat charge for the blowers that it charged the authority. So the way that UBI and McCrossin have characterized it is that you should totally take those out because no cost was associated with them to the authority. And that was because it was done as a no-cost change order, the way that it's been characterized, because it was the only way to get the authority to accept the change order to include the UBI blowers. But the problem with all that is that to the authority, it paid for all of the blowers that it obtained from McCrossin, who obtained them from UBI. And the no-cost change order was a function of the contract because UBI and McCrossin couldn't offer a change order to get different blowers than the Roots blowers and say, oh yeah, and then it's going to also cost you an additional amount for these other 3 that we're going to have to put in for ease of maintenance. So the exchange, it was a whole package, and so I don't think that we can go in and shave those off the total foreign cost because from the authority's perspective, it paid for all of those to get a full blower system. And
I'm sorry, questions from any of my colleagues? Mr. White, if you want to take a minute for summation, you may.
Sure. Thank you, Your Honor. Again, I very much appreciate the court taking this on. This is, as you noted, Your Honor, this is a case of first impression. I think it's going to be very valuable for the court to provide some guidance on this law in terms of how it interacts with, how public agencies can perhaps calculate under circumstances like the authorities here. And I think it makes sense to look at the 75% domestic requirement because that's what advances the United States steel industry. So I think that's what the focus should be on. And thank you very much for your time.
You prefer, but respectfully, we have a pretty strict policy that you don't get rebuttal by repeating what each other said. So hopefully you have this divided and one of you can proceed.
Good afternoon, Your Honors. This is Paul Logan. May it please the court. I will be speaking to the issue of cost. My colleague, Mr. Williams, will be addressing the balance of the issues with regard to the standards of review. And I want to target in on some of the questions that Chief Justice asked about the two issues in particular, of whether or not the 8 plus 3 equals 11 were which costs that we take into consideration, and then the components, because it's really important that from the standpoint of the contractor and supplier's perspective, that they look at the language of the act and they know exactly what it is they are required to do. And I will disagree with my colleague with regard to could the UBI blowers be used as opposed to the roots blowers. The standard on the bid was a standard for Crossing UBI to meet. UBI blowers met the standards of the specifications. What the authorities desired to do, which was outside of the scope of the agreement, was to make conformity with all the blowers it wanted. And what it said to the crossing was, you may go forward so long as you provide at zero cost 3 additional what they call bare shaft blowers. They're not the same as was bid. And there was no change in the as bid price. Those 3 bare blowers nothing was paid by the authority for them. What the act proscribes is paying for violative steel products. The authority paid nothing, zero. And the reason we know that is there is a $0 change order. That was what was done at and during the project. So we have 8 blowers, a 8-blower system. The question then drops down is, well, at what level do we look at costs, and at what level do we do the mathematics? And what was I believe the question was asked earlier, who had the burden of proof? I believe Mr. Chief Justice, you asked. And there was a certification given by UBI and McCrossin that everything was compliant. There was a question raised. And during the course of that questioning, the authority was given absolute access to answer any questions it chose. Chose not to ask any. The documentation that was provided to the authority included from the component suppliers to UBI a statement that says at least 10% of our component cost to UBI is United States content. The record shows that there was no dispute that that was accurate, yet that was disregarded. So the question of what were the real numbers? Well, what the trial court on review said was that was not correct for the hearing officer to interpret costs to exclude that which was of record and not disputed, that 10% of the components to UBI was United States content. What the trial court also did was say, I am looking at this as 8 plus 3, and therefore I'm going to look at the costs of UBI at the level of those 8 blower systems And when you do that, we're coming up with 24% foreign content. So that the math shows that no matter how you do it, just looking at the 8 they paid for, there is compliance. So that was the major reviewable matter, which is a matter of law, because as your honors have in other cases pointed out, if the legislature wanted to define things, they could. But here they didn't define anything. So they kind of left everyone to kind of wander around as to what's a steel product. Because I will, again, disagree with my colleague. This is not just about the steel. It talks about when there is foreign steel components, you look at the articles. And I believe I cited to the case of Trojan Technologies that pointed out that steel products could be as absurd as a wooden chair with a steel screw, because that would meet the definition. So what we have now is not just an issue of what are the costs, it is what is the cost and at what level do we look at it? How far down do we go in the chain? Because the math is what the authority paid and what UBI certified, with no contradictory statement from anyone of what the steel, the foreign content was for those 8 systems that were actually paid for. So I agree that there is some vagueness and curiousness about what does it mean, but in this narrow application, your honors, I believe that both McCrossan and UBI gave the required documentation, certification, without contradiction of what those numbers truly were. Trial court didn't change the numbers. Commonwealth court didn't change the numbers. They just looked at what level on a horizontal basis and what level on a vertical basis do you come up with the methodology of the calculations. So I think that as to the first of the 2 issues, the Chief Justice pointed out, 8 versus 11, proscription says you can't pay for non-compliant. They didn't, and therefore those 3 are out. We look only at the 8 that were furnished and paid for. From the very first bid, from the date of the bid, all the way through performance, that price didn't change, and the 8 didn't change. They just changed manufacturing parts.
Could I jump, counsel, could I jump in on that? With respect to the denominator, you've mentioned price and deductions. And one of the questions I'm wondering about is Section 6 is concerned with the cost of the articles. Why isn't the denominator the cost to UBI of acquiring the materials, period?
Well, Justice Wick, the reason is that we start out with the cost. It goes into the who's not allowed to pay for what. We start out with a cost component, and this is where we start at what level on the vertical chain do we work. It's that the authority is not permitted to pay for certain articles non-compliant, 7525. Even when we go down the levels, which frankly should have been the cost, could have been the cost of UBI just to McCrossan and McCrossan up to the authority, the denominator has always been, and nobody's really challenged it, that it was the cost that the authority paid to McCrossan. Across the board, we've all agreed, or at least it hadn't been disputed, that that's the right denominator.
Can you just can you explain that again? I'm sorry. I think I'm very dense here. There seems to be a presupposition in that regard. Maybe I'm the only one who's not completely following it, but why is the denominator authority specific? I guess I thought the denominator ought to be the cost to UBI, which acquired these materials, needs to certify 75% of that. Well, why are we looking elsewhere?
So what the Act says is that we start at the governmental entity that is prohibited from paying for certain items. And that number, at least what I believe the Act says, and it's not the epitome of clarity to be sure, it has always been focused upon what the governmental entity can or cannot pay. And the amount that has been requested back isn't going down that food chain, if you will, down to UBI and McCrossin. It's what the authority has asked for is the entire amount it paid to McCrossin. So that denominator, by both action of the authority and the act itself, the denominator is what the authority pays.
So with respect to what the authority, you're saying it's always been the case, it's always been the case. Is this a custom of the industry? Is it a practice and custom of the industry? Why is that the unambiguous reading of this statute rather than the one I threw out there?
Justice White, I am not saying that it is unambiguous. I am saying just the opposite, and I think our brief suggested that. And therefore, what has been the practice, and the practice is embraced in the certification documentation, which is a publication of the Department of General Services. It's called an ST3 form. It's not produced by either the authority or the contractor. It's something that's state published. And that's how those numbers are recorded. And that's how the math has been done as adopted by the Commonwealth. And that's what the ST forms, as they are referred to in the industry, show. So we start out with a number that is the authority's number that they're asking for 100% back, which is a whole different story for a different question. But then we get into, well, what is the cost here? If we just stay in the lane of what the authority bought, which is the 8 blowers, from day one to day done, that's all they paid for ever. And you look at the components, even if you set aside the 10%, there's compliance.
Counsel, it's Justice Donahue. Before you get off onto what I think is a little bit of a different issue, let me follow up on Justice Weck's question, because I think I have the same question. If the cost is determined in the manner that you're suggesting, the markup to the authority could be jerry-rigged to affect the 25% bogey that you're looking for. And so the pure way to look at this is the cost at the level below the markup in order to determine the appropriate percentage of made in America steel.
Justice Donahue, I understand the issue. Let me answer it 2 ways. The first one, very precisely, there's not a suggestion that that happened in this case.
I didn't say it did, but I'm saying that it could. That's the problem with not working with the pure cost of the product.
That question actually came up in argument during the Trojan Technologies matter, which is how far down the line do you go? If you're looking at the pure cost of steel, that's almost insignificant versus the manpower to actually fabricate it into a form, into the handling, the milling, all of the things. Well, if we're just talking about raw steel, and in fact, what Trojan Technology said was that U.S. steel, for definitional purposes, is, quote, virgin U.S. steel, which, by the way, is not manufactured in the United States any longer. So virgin U.S. steel is the cost. So we need to go all the way back into, well, what is that cost? It's probably de minimis under the sets of circumstances, because it's all the handling, the molding, the milling, the transportation, the shaping, the assembly. It doesn't say in this act where you stop going down or how you go forward. It has, as Justice Weck pointed out, there seems to be now an industry acknowledgement of the denominator, but the numerator is, and in this case, it points it quite clearly out. That's why UBI went to its vendors and said, you tell me what your cost components are. They were reluctant to do that, obviously. They don't want their costing getting out in the world. So they said, at least 10% U.S. content. And these entities are from the United States. The UBI is in Georgia, United States. So we have work done by McCrossin at the site. That's United States added component when it is installed. We have UBI in Georgia taking these components, doing what they did to them, adding value. They purchase it from entities that are cited in the United States. Yes, there is an indication that certain things came from China and other places, but how far down do we go? And the answer is what we provided to the authority was more than sufficient, even on the worst case scenario for UBI.
But you see the problem, but you see, if I can build on Justice Donahue's question, that the problem, and again, perhaps I'm missing a lot here, but the statute, which we're supposed to liberally construe, it's a protectionist measure, right? It's to help the domestic industry, obviously. So the statute says 75% of the cost of the articles. Boom, there it is. Now, the more that we interpret by adding layers of added value, profit taking, deductions, additions, price adjustments, etc., the more you are, the more I suppose you're what are you doing? You're fattening the numerator, right? You're getting further afield from whatever the I guess true math, so to speak, that I think the statute's calling for us to find.
Justice Beck, I understand the dilemma, but the act, while liberally construed, is also not supposed to impede those who do those things like add value not to include in their cost components. The United States looks at the last substantial transformation test when you look at made in the United States, quote, the last substantial transformation. If we use that standard, the last substantial transformation is when all the components are finally assembled into one. And that would have happened at the authority site. This is not the epitome of clarity of an act, but for this particular, and I come back to, for UBI and McCrossin, and for UBI in particular, I heard my colleagues say, well, there's a multi-million-dollar project. UBI's entire costs are on the table. This is 100% UBI. So they get zero or they get paid. That's what the issue is here for UBI. So where do we draw the line? Here is what the Commonwealth Court looked at when it looked at what the trial court decided. It looked at, here's the information that the numbers that the hearing officer came up with. And as a matter of law, which is his plenary review and the plenary review of the Commonwealth Court as well, looked at what do those numbers tell me? Not challenging the act or saying that the act probably needs an overhaul, which perhaps it does, but looking at what we had in front of us then. Trial court said the hearing officer disregarded information that he shouldn't, included in costs that he should not, and came up with a number on a plenary review by the Commonwealth Court. The Commonwealth Court said, I'm going to look at what the trial court did and accept all the numbers that the hearing officer accepted and came up with the exact same conclusion. On this case in particular, UBI and McCrossin complied with the act. With regard to guidance to everyone and anyone who games the system, let them beware that that's a problem, which is why the act says that even if the authority wouldn't do it, the Attorney General of Pennsylvania could. So that there is a police power out there that if someone thinks the system's being gamed, there is a way for that to be triggered. But that's not this case. And I think I've overstepped my time for my colleague. I apologize if I took all of his time as well, but I try to answer Your Honor's questions. Well, now, if there are no other questions to me, I'd like to hand it over to Mr. Williams. I'm still here, so if you have any questions.
Yes, if it please the court, my name is Tom Williams. I represent GM McCrossin Inc. Paul, you did just in response to the justice's questions, address a lot of the issues and things that we talked about that I may cover. But initially, I'd like to address a question that Judge Saylor raised, leaving the math later, and certainly I'll chime in on any questions that you may have on that issue. But clearly, what we have here is a situation where the authority has had the benefit and full use of McCrossin's labor, material, and equipment for going on 7 or 8 years now, I think it is. As far as we know, in accordance with the record, everything is working fine. And if there were any issues at all, McCrossin addressed them. So for the authority to be seeking a complete return and essentially a forfeit of all the monies earned by UBI and McCrossin is simply, it's a windfall for sure, an unjust enrichment for them. Now, there's two key phrases in Section 5 of the Act. One of them is, any person by any public agency which should not have been made, any payment which should not have been made. Again, that's not defined, that phraseology. But as the court interpreted, the Commonwealth Court interpreted that in their footnotes more than once, indicated that, even though the trial court found that there was no violation, the Commonwealth Court went on to say, and I think reasonably so, if you've got the benefit of the use, you shouldn't have to forfeit all of the money being a contractor here. At worst, we're talking about the monies that should not have been paid. And what we have, if you take the authorities number, there is 3% more foreign component than there should be on this project, if you take the authorities' position. Well, that's the amount in terms of what the Commonwealth Court found.
Chief Justice Barron, respectfully, I'm going to interrupt you because what I'm hearing is argument as to what the remedy should be, and we did not accept the case on remedy, and we've not prepared the case on remedy. If we affirm the case is over, if we reverse, then somebody below, notwithstanding the passage of time, which is implicit in the judicial system, as you well know, is going to have to figure out the remedy.
Very well, Your Honor. I'm prepared to answer any other questions. I know Mr. Logan addressed many of the issues that we have.
Well, just go ahead, Justice Donoghue.
No, I have nothing. I'm fine. Thank you.
Okay. then let me ask you, because I'm still struggling. I've been sitting back and listening and not questioning because I've been trying to process this. Let's just say that the authority paid McCrossin UBI $241,000. I know that that's not precise on either side for these blowers, but I'm taking a number in between the two, 241,000. They got 11 blowers. They got 8 blowers. Does the 241,000 go into the fraction, or does another number go into the fraction because you divide by 8 or you divide by 11? Is that the ramifications of that argument?
The ramifications, Your Honor, are that the record showed that there was a fixed price contract that McCrossin gave for 8 blowers originally, and then there was a change order issued in which the authority got 3 more free blowers and didn't pay any money for them. Those are free blowers.
But my question to you is, so what? In the context, I'm not trying to be flippant, in the context of this fraction, why does that make any difference?
Chief Justice, may I answer that, please? Because what the hearing officer did was take the quote-unquote foreign component of the 3 no-cost blowers and added it into the numerator. If you stay with just the 8 blower systems and their component costs, you get a 24% foreign content. If you add in the foreign content numbers from the ones that weren't paid for, then you skew the number And that's what happened here. So the number,
And Mr. Logan, I'm happy for you to answer it, and maybe I'm going to have to go back and understand this and study it. Is the number that's going into the fraction? I said 241, 243, 239, 245. I don't care. Is it that number, or is it something different because of some division and multiplication?
it is that number, which is the amount that was paid. That's the denominator, Chief Justice. That is the denominator of the fraction. It is the amount that the authority paid to McCrossin for the 8 blowers.
And where does the import of the foreign content of the other 3 blowers show itself in the fraction?
When the hearing officer did the calculation of the foreign content, he took the 8 blower foreign content and then added to it the foreign content of the 3 blowers that were not paid for. So the numerator got skewed higher.
I got it. Thank you. Finally, appreciate it.
Can I follow up on that? The contractor requested the change order, correct?
Contractor asked for the change order. This is a public contract that has a basis of bid, and it was not a sole source. So the contractor has the absolute right to say, here is what meets your specifications. And what the authority's engineer said is, yes, UBI meets our specifications, but we would like to have all the manufacturers the same.
I understand that, but the contractor, I'm hung up on this notion that something is actually free. Very few things are actually free. So the contractor asks for a change order. The only way change order is going to be agreed to is if this other contingency is met. Therefore, there's nothing free involved in that exchange. The contractor gets what it wants, which is a change order, and the authority in this bargaining position said, fine, you get the change order, but we get these other blowers. I don't think that's free.
I understand your perspective, but I can assure you of this, that no one from the contractor or UBI side of the table ever had the idea of giving 3 additional blowers at no cost. What should have been approved without question is UBI for the 8. It's the authority who said, I'll tell you what, I'm going to say, I'm only going to approve this if you give us 3 more. So the table is actually turned the other way around. It wasn't.
Did they have the right to withhold agreement to the change order?
I'm going to suggest the answer is they could have, but I think they would have been overstepping their bounds a great deal and done something which they're not allowed to do in public bidding, which is sole source. So they said, well, I don't want to say it quite this nefariously, but a nod and a wink, we'll let you do what you're allowed to do, but only if you give us 3. And that's exactly what happened here.
And they had a cost to you, right? And just to follow up, those 3 blowers, they had a cost to UBI. UBI had a procurement cost.
Correct.
Okay, so I come back again to I won't re-put my denominator question, but I guess you and I are looking at different levels of abstraction, and me less competently, I'm sure, but I'm just not there.
And let me follow up. Oh, I'm sorry. Justice Weck, are you done? Let me just follow up, Justice Weck. There's circumstantial evidence, if you will. I know there's not direct evidence that McCrossin's cost of $240,000 and the authority's cost of $243,000 is not sufficient profit for McCrossin to charge the authority. And what's happened there is McCrossin did math, supplied the 3 additional blowers, and that brought those numbers so close to each other. Is that an unfair assumption from the evidence?
All right, follow that, Justice.
What I said is that I look and I see McCrossin paid UBI $240,000, and McCrossin then charged the authority $243,000. and $3,000 appears to be a insufficient profit on a $200,000, $250,000 item. And so what I would characterize, not as speculation, but as circumstantial evidence, what I thought happened there is that UBI bought a lower 11 blowers and it cost them $240,000. And they ate their profit by selling them for $243,000.
Justice Mayor, that's not exactly what happened. There was an agreement for UBI to sell to McCrossin the 8. And the amount that you see of the 240,000, 239.8 is what it is, was UBI didn't say, here, McCrossin, here's the 3 for free. McCrossin had to pay UBI. So in order to keep this project going, McCrossin made that command decision. All right, we're just going to keep going. So that's what happened here, and that's what the evidence would show and does show.
All right. Thank you for that. Any further questions from any justices? Mr. Williams, you got cut off. Would you like another minute or two, or have you concluded your remarks?
I'm concluded, Your Honor.
All right. Then thanks to all counsel. Interesting, complicated case, and we'll take it under advisement. We'll take a 5-minute break while we treat.
Thank you.
Take care.
Thank you, Your Honor.
Thank you.
The next argument is Daniel Mohn versus the Bucks County Republican Committee. Representing Mr. Mohn is Joshua D. Bond. Representing the committee is Mr. Joel L. Frank.
This appeal raises the issue of whether the trial court had jurisdiction over a challenge to the Bucks County Republican Committee's removal of one of its committee members. The issue is whether the committee's decision constitutes a purely inter-party matter protected from judicial interference by the committee's federal constitutional right to political association free from state interference, or conversely, whether it involves an adverse impact on the democratic process necessitating court involvement. The trial court granted summary judgment in favor of the committee, holding the court lacked jurisdiction over what it deemed an inter-party matter. In a divided opinion, the Commonwealth Court affirmed it held neither a public policy nor democratic process was implicated in the committee's enforcement of its bylaws. So this case now provides us with the opportunity to interpret the scope of our 1966 decision in Bentman versus the 7th Ward Democratic Executive Committee. Mr. Bond represents the appellant. Feel free to proceed.
Thank you, Chief Justice Baer. May it please the court. The issue in this case is whether a publicly elected officer of a political party may seek judicial review of his or her disqualification from office. Trial courts should exercise jurisdiction in these cases because publicly elected committee persons perform important public duties, including nominating candidates for vacancies in local public offices. My client's disqualification from his office deprived Republican voters of their voice in the Republican Party with no opportunity for judicial review, where a small private group is entrusted with powers that directly affect public duties. Courts must act as a neutral arbiter to ensure such powers are exercised non-arbitrarily and in compliance with state law.
Counsel, since you paused, I guess you're ready for questions. If I could ask you one, what is the limiting principle then? By your argument, I'm not sure what would be the principled basis upon which we would accept jurisdiction of your case and then refuse jurisdiction on, say, a case involving some other intra-party dispute. Isn't the cleaner line to adhere to the line that SCOTUS has been adhering to for the past several decades, which is to say that we don't get involved in intra-party matters at all, save, I suppose, for 15th Amendment related cases?
Yes, well, if you look at the rules of the Republican Party of Bucks County, and this is at the record at page 64, it's Rule 8, Article 1, Section B. It provides that committee persons in Bucks County are to fill vacancies in local political offices. And that's what is the key fact of this case that brings this case into the public realm. Now, as for if you're going to draw a rule, my position is that these candidates, because these party officers are publicly elected to represent the voice of the people in their party, that the court should expand the Bentman precedent to impact any disqualification of a committee person should be subject to judicial review. That would be the cleanest rule, and it would avoid any confusion on the part of trial courts as to when or when they should not exercise jurisdiction, this court may expand the Bentman precedent, and it should be expanded because these committee people perform important public duties. And rather than parsing whether the alleged misconduct occurred before an election or after an election, the cleanest rule would be to, because committee persons generally throughout Pennsylvania exercise these public duties, to have a bright line rule that courts can intervene anytime there's a disqualification of a committee person of a political party.
Just a brief follow-up, counsel, on that. Then, were we to accept your invitation, and I have to give you credit because far from restricting Bentman, you would expand it. That's an aggressive argument. I have to give you credit for that. So supposing we take you up on that, shouldn't we then anticipate a flood of corresponding claims from the parties, the party respondents to those actions, that their rights of association have been violated? Because then aren't you compelling party organizations to associate in ways that arguably violate their First Amendment rights?
This goes back to the duties that these committee persons perform. They perform public duties, and the political parties are entrusted with making the associating with these individuals. They should not be allowed to disassociate with these individuals unless they follow their own rules.
Counsel, Chief Justice Barron, let me just follow up because that's the second time you made that point. It reminds me by analogy of the free electors jurisprudence of the U.S. Supreme Court, I think in its last term, that if you're elected to cast the ballot for a presidential candidate, you can't change your mind. Here, what the United States Supreme Court said, as a matter of the political association's right under the First and 14th Amendment, was that your client ran for the Bucks County Republican Committee. He signed a pledge to abide by them. And your argument is that he wants to be a free actor. He should not have run for that position if he wants to be a free actor. Your suggestion creates chaos among political parties. You know, that you run to, that your party supports candidate A and works for them, but you're saying every committee person has a right to pick their own candidate. So there is no committee. And isn't that the evil the U.S. Supreme Court was trying to deal with?
The political parties, if these matters were adjudicated, the political parties would still be permitted to disqualify these individuals as long as the individuals actually violated the party's rules. And it's been my client's position from the very first letter that he wrote whenever he was notified of this of these charges, that these charges are not a prima facie basis of a violation of the party's rules. So that could still be adjudicated.
Yeah, but you're making a completely different argument now. You're saying on the merits he should have won. And we really didn't take the case to address the merits. That's frankly not our concern. We took the case to determine or question jurisdiction under Bentman, but also under La Joliette, I think it was, the federal case, in which the U.S. Supreme Court said that the committee had a constitutional right to do these things. And they set the floor, SCOTUS sets the floor in terms of constitutional rights. I'm not sure that we can grant you more rights under Bentman without running afoul of minimal federal right of association under the Juliet.
Counsel, this is Justice Doherty. I have a question, and I'm still trying to ponder or accept your expansion of Bentman. As the Chief Justice said, we're here to decide whether we have jurisdiction, and the aliquot question granted was under Bateman, do we? So the question I have for you, in this particular fact pattern, what was the direct relationship to the performance of a public function?
It's my client's duties as a committee person. He clearly, if there was a vacancy in public office, he clearly would have had to participated.
But the counsel, I apologize. That's exactly what Bentman indicated, that there was a direct and substantial relationship because they were choosing a vacancy. That was imminent. There was no immediate vacancy. So without it, and in your own language, if they could, becomes part of their duty and responsibilities. But my question is very fact specific. Share with us what was the direct event that had to deal with their public duties, not what could be. Because if we were to follow your lead, then every case is subject to judicial review when Bentman is actually providing a limited use by making sure that there's a direct and substantial relationship to the performance of a public duty. So I'm really, really confused as to this. The linchpin here is, what was the direct relationship or the direct performance, not the potential? Can you share with us what the direct performance was?
Your Justice Doherty, that is, I answered this question before the trial court. The Commonwealth Court relied on my answer to this question. I'm saying the same thing I've been saying all along, that we've never argued that there was a vacancy in a political office in this case. We've never argued that. I have to be candid with the court. I mean, there was not.
But I got it. We all know that there's not it. But I'm asking you. You just asked us, and with all due respect to our colleagues on the trial and the intermediate appellate court, it's our decision which will control how this is applicable throughout Pennsylvania. So I specifically say, under Bentman, if there's a direct and substantial relationship to the performance of a public function by a political party, we can get into jurisdiction. So with this particular case, I just need to understand what it was that you're alleging, not a potential. We know that a part of a committee person's duties, when there is a potential vacancy readily available, they must be seated to take part in that. But when there's not, and you're asking us to take jurisdiction in contradiction to the rules of the Republican Party, share with us. Give us something to hang our hat on. What is it?
In Bentman, the Bentman decision did not only talk about the fact that there was a judicial vacancy occurring. The Bentman decision talked about membership on the committee and the concomitant right of participation in the selection of public officers. There's a direct and substantial relationship to the electoral process, has to be a matter of judicial concern. So I'm reading Bentman. Bentman is more broad than what your question suggests. It's the membership on the committee that's protected, not only in the event that there is a actual vacancy in judicial office. And another issue is that if a vacancy would arise, this litigation shows that there would be no remedy. This case has taken nearly 5 years to work its way through the courts. If there had been a vacancy, there's no way that Mr. Mohn could have adjudicated his rights in a timely fashion before the vacancy was filled.
But counsel, the remedy, you want to read Bentman, which is an outlier case in and of itself, but you want to read it in a vacuum, as if SCOTUS had not decided La Follette, Cousins versus Pagoda, California Democratic Party versus Jones. And it's pretty clear, reading that evolution in the, 50 plus years since Bentman, that Bentman was misconstruing Smith versus Allwright, which was a racial case. And in any event, to say that your client has no remedy, doesn't that give no credit at all to the Bucks County Republican Party and the Pennsylvania Republican Party? They have rules and they have procedures and hearing rights. Isn't that his avenue for relief? Because if it's not, then we'll probably have to set up an entirely new court system just to hear party disputes in Pennsylvania, Democrat Party disputes, Republican disputes, maybe Green Party disputes, or what have you.
There needs to be a neutral arbiter. This case demonstrates that the Republican Party of Bucks County was not a neutral arbiter. Mr. Mohn notified them that the charges against him were not a prima facie basis for his removal. He stated that in writing numerous times, and they proceeded to hold the hearing anyway, even though it's clear from the record that his alleged conduct, even if true, was not violative of the rules of the party.
Thank you very much, counsel. No other questions for any justices? So we'll hear from Mr. Frank.
Thank you, Chief Justice, and good afternoon, members of the court. My name is Joel Frank from Lamb-Mackerlane, representing the Aplt Bucks County Republican Committee. At the outset, I'm sure you recognize this is not a partisan issue. The Bucks County Republican Committee, like any political committee, through its internal self-organized apparatus, is permitted to construe its own governing rules and to disqualify elected occupants of its offices from participation in its affairs by exercising its own judgment, free from judicial interference except for very limited circumscribed circumstances, none of which are existent here. So the answer, quite honestly, to the question posed in this court's December 29th, 2020 order is no. This is purely an intra-party disciplinary matter that the U.S. Constitution has reserved to Aplt to address free from government intervention. The Pennsylvania Election Code, specifically Section 2842, recognizes that any party organization is somewhat hierarchical in nature by providing that any duly elected or appointed members shall be subject to the control, direction, and supervision of the political committee of which they are members. Gordon, in following Bentman, really only permitted court involvement in intra-party matters when a political party engages in imminent, cognizable conduct constituting state action, as some of you justices have already pointed out, that is direct and substantial for the selection of public officials. It's almost a bad faith element to the analysis, quite honestly. However, there's a good reason in practice to read Bentman in the manner that Gordon did. Bentman actually establishes a very narrow exception, again as recognized by some justices, to well-established U.S. Supreme Court precedent that pursuant to the First and 14th Amendments, Bucks County Republican Committee, as a political association, has the right to be free from government intervention, and consequently courts may not properly get involved in an intra-party dispute. It would be quite a slippery slope and an opening of the floodgates if courts were to be able to become involved in any dispute involving any office that at any time has any duty, no matter how remote, to at some point select high public officials. That is not what Bentman stands for. In Bentman, there was a direct bearing alleged between the party's ouster of committee people and the committee people's imminent duties to fulfill their duties to select higher elected officers. That party's conduct was done to affect the outcome of an imminent vote, thus affording the opportunity for judicial review. Not so here. Mohn's claims about his inabilities to fulfill his role are solely pretextual and speculative. There's no identified state action by the Aplt amounting to a direct and substantial participation in selecting public officials in lieu of an election. As I think Justice Doherty pointed out, the trial court repeatedly asked appellant's counsel in what committee, maybe it was Justice Wecht, as I stand corrected. The trial court repeatedly asked appellant's counsel in what committee person, duty, or activity was Mohn specifically being deprived from participating, and Mohn understandably was unable to identify any such imminent cognizable duty or activity. With no state action in which appellant was then entitled to participate, but was denied due to his disqualification. As recognized by certain justices by your earlier comments, the holding in Bentman is much more discreet than that proposed by the appellant, because there the political party was participating in state action when it was substituting its own internal vote for a primary election for the subject judicial offices. To accept the appellant's strained, expansive reading of Bentman would have the exception swallow the rule, the U.S. Supreme Court precedent, and the First and 14th Amendments with it. Consequently, in this circumstance, courts should not become involved in this intra-party dispute, and the Commonwealth and Common Pleas court decisions should be affirmed. Thank you, Your Honor.
Counsel, can I ask you a question on that?
Counsel, it's Justice Donahue. And I understand your argument, very well put. The problem that I'm having with this is that under your analysis, the entire process of voters in a closed primary going to the ballot box and voting in a closed primary for their choice of candidates for committee people means nothing, because under your analysis, the day after the election, either political party can say, we don't want any of those committee people. Thank you very much for casting your vote. But we have our slate of 17 people that we've decided we want to have serve as the committee people in our county. That being said, aren't we nullifying the entire process set up in the election code for party members? This is not an open primary like we had in Lafayette. This is a closed primary. Aren't we totally nullifying that aspect of the election code that lets members of a political party go to the polls and choose committee people for their party?
Understood, Justice Donahue, and good question. However, quite honestly, I believe it's a fair assumption to go ahead and make that when an electorate of a given party votes for a specific committee man or committee woman, they're going ahead and doing so, believing that that committee man or committee person is going to go ahead and adhere to their own party's rules. That was not done here, as was established by the comprehensive summary judgment record.
I don't know how you could do that. I certainly wouldn't. I mean, people vote for committee people because they know who these people are and what their views are and things of that nature. But I mean, if I'm correct, I think I'm understanding your argument, which is the determination by the electors of any given party on election day is irrelevant. The day after the election, the party can say none of those people are committee people for our party. Here is the end of discussion. No judicial review, period. It's an internal party matter.
Well, no, I mean, there would be judicial review if there was an imminent action that was related to the party's attempted removal of a given committee person.
I understand what you're saying, but I mean, that does not negate the premise that I set forth. Assume there is no imminent vacancy to be filled. The day after the election, the party, either the Republican or the Democratic Party, could say, we don't really actually care who the committee people were that were elected by members of the party. Here are our committee people. Done.
Well, that's not
the result of this.
Sorry.
I'm not saying that's necessarily wrong, but I mean, that has to be the conclusion you reach if there is no jurisdiction to review action of the hierarchy of the party.
Oh, I'm not saying I've never contended there's no jurisdiction. I mean, there's jurisdiction under those limited circumstances. They just happen, those limited circumstances, as recognized by the Pennsylvania Election Code itself and U.S. Supreme Court precedent, just don't exist here. I'm not contending that there would never be a circumstance.
But so then you're agreeing with me. The day after the election, either major political party in Pennsylvania, tomorrow, for example, I don't know if committee people are being elected in this municipal election. Let's assume the discussion that it is. Tomorrow morning, assuming all of the mail-in ballots have been counted, the Republican Party and the Democratic Party can say, we actually don't care what the results of that election are. Here are the committee people who are going to serve in our party.
I guess that's Justice Donahue, that's a possibility. I can't tell you it's not a possibility, but again, there's due processes that are already set up to address that and remedy such an occasion.
Mr. Frank, are you saying in response to Justice Donahue's hypothetical that could only be done, the nullification of the elector's will could only be done if the process complied with the party's rules and regulations? Is that what you're saying?
I am, correct. Properly done, correct. And if not, then that set of circumstances, which again are non-existent here, could go ahead and be subject to judicial scrutiny.
Well, in addition to that hypothetical, yeah, I'm sorry. Go ahead.
No one would ever get to look to see if the party rules were followed. No one would ever get to do that because your argument is that is a purely intra-party dispute. There is no jurisdiction of the court to look at why the action was taken.
And there might be consistent views from county party to county party, consistent rules, right? Who knows what the internal rules are of a political party's county committee or state committee?
Correct. The details of that, Justice Todd, you're correct. There can be some variation as long as they overall comply with the lead organization, whether it's the GOP or the Democratic parties.
Well, Council, there's a political consequence, right? So if there's a rogue ward chair, that person presumably is accountable to the county chair, and the county chair presumably in a rogue action responsible to the state party apparatus, and they can remove and do what have you, because there need to be some principled limits to our jurisdiction in intra-party matters. I'm interested in testing that with you for a moment here. Would you agree, consistent with Smith versus Allwright and other cases, that had Mohn been, am I pronouncing his name right, Mohn?
Yes.
Had Mohn been removed for racial reasons, that would be impermissible, right?
Correct.
So 14th and 15th Amendment. How about, suppose Mohn was removed on the basis of religious creed?
I think that in itself would be protected and subject to judicial review.
Okay. How about if Mohn was removed because he sought to vindicate his Second Amendment rights? Second Amendment. So he showed up at a meeting, armed, was told he can't be there, refused, was removed. Is that a constitutional right that would be vindicated here?
A little bit more questionable. Again, it's a personal perspective, I guess. I'm not sure how to answer that question per se, but again, I think we're going, and I'm happy to engage this dialogue with you, but we're going above and beyond what the Supreme Court says.
But I'm testing the limits. The reason I'm testing your limits is, it's one thing to assert that intra-party discipline is something the courts cannot engage in. They have to get their remedies politically or through their state party apparatus. But then you have an exception for race. You've said there's an exception for religion. You're not sure about gun rights. What about ethnicity? What about gender affiliation? What about gender preference, et cetera, et cetera? I'm trying to see what the limiting principle is.
I think there would be, a federal civil rights action. In fact, if there was any action by any organized political party to go ahead and try to constitute or reconstitute its own committee based upon any of those premises that you just went ahead and identified, Justice Weck. But again, that's not where we are, in this case. And I think I know you know this, but again, we're talking about Bentman and its very limited exception to the overall Supreme Court doctrine that's been, as you pointed out earlier, in place for 50 plus years, that inter-party disputes typically are not subject to judicial scrutiny.
Just one more point. You keep trying to distinguish Bentman. Why don't we just overrule Bentman? Isn't it just wrong, looked at in the fullness of time with 50 plus years of SCOTUS precedent going the other way? Isn't Bentman just wrong and shouldn't it be overruled?
Well, let's remember exactly what happened with Bentman, right? Bentman, there were preliminary objections. Bentman was never even heard on the merits. It was a preliminary objection and taken as we must, with the favorable play, what was pled in the complaint. Then the Bentman court held that, yes, okay, there can be judicial scrutiny under these specific limited set of circumstances. So Bentman's an exception. If you would like to overrule Bentman, I can't say that's improper. But it would go ahead and basically realign the law to what the Supreme Court has indicated. But Bentman, as currently as you recognize, is what it is and stands for what it currently stands for. Again, recognized by Gordon too. I think Gordon probably properly interpreted Bentman when it went ahead and enhanced or further refined what Bentman stood for from the Superior Court's perspective, of course.
Councilor, it's Justice Donoghue again. Let me get back to, so if I'm on, and I'm, we do try to set, outer limits on what can or cannot be done when we decide cases like this. So if I'm understanding this correctly, either major political party could decide the day after an election not to seat any or all of the elected committee people just because they don't like them. No court could review that because there is no constitutional issue involved, correct? Is that where we're going with this? I'm not suggesting it's right or wrong. I'm just asking if that's the logical conclusion of what you're suggesting.
Well, I guess it's a possible conclusion. Yes.
Okay, and under our election code, the two major political parties are treated in a very privileged manner in a lot of circumstances, number of signatures on petitions and things of that nature. And critical to this case, they are given the privilege of using the polling places on election day where voters can cast their ballots. And I'm just trying to get to the root of the reason why that happens at all. If the will of Republicans, the will of Democrats makes no difference in terms of what the hierarchy of either party can do, absent the constitutional considerations that Justice Weck has run through.
Well, again, I understand your point, Justice Donoghue. However, there are bylaws, right? I mean, there are bylaws that are defined by each of the political parties. If there was action taken by either of the parties, the main parties or some of the more subordinate parties, I'll say, that's not an accurate term, then of course there would be potential, scrutiny. But once you get into the merits of it,
not by a court, there wouldn't be any scrutiny by a court. That's why we're here. We're here because the argument is a court has no jurisdiction. So forget about what the bylaws say. It doesn't make any difference, does it?
Well, I think what the bylaws state do matter, because if in fact there was state action which was occurring, right? That's one of the fundamental premises of both Bentman and Gordon and some of the U.S. Supreme Courts. That's a given fundamental premise, right? We're starting from that. If there's no state action that was taken into account on a given situation, that's a different scenario. It's when there is state action, when the party is supplanting its judgment, its role for that of an elected person, that's when the courts would go ahead and have ability to come in and address the situation.
the constitutional considerations that Justice Weck ran through with you a few minutes ago. But that being said, absent any constitutional barrier, neither major political party is bound by the vote of its members on election day.
Well, I mean, I think they are bound by the votes, of the. And listen, I agree. They can't willy-nilly, right? Someone can willy-nilly go ahead and for no reason. That's why Bentman had the limited exception, that there needs to be state action specifically tied to conduct that's being deprived, that you're deprived from an elected committee woman or committee man under a given set of circumstances.
Okay, I understand we're going in a circle now. Thank you.
Thank you.
Mr. Frank, I've been trying to listen and think about through all of this, but doesn't Bentman say, you should know it better than I do, that if the action of the political committee impacts a public function or the public interest, that a court can be involved? Is that an accurate statement of Bentman?
Yeah, but at the same time, it needs to be like, for example, the court couldn't issue an advisory opinion. There still needs to be an imminent, cognizable action and event attendant to that, Chief Justice.
Justice Donahue's hypo that the public has elected all the representatives to the committee, and the committee chair, because she or he has a peculiar vision of where they want to go, can dismiss them all and substitute them. It just, and again, I've tried to listen, but before you quit, I want your view. That seems to me to involve public function and public interest. It sounds of substantive due process to me, and I would think that in a violation of public policy, and I would think and the only issue before us is, does the court have jurisdiction? Everybody's going to be put to proof in due course. It would seem to me that it's almost a no-brainer that a court has jurisdiction under a substantive due process, public policy, attack on democracy kind of.
Under that scenario, I would not disagree with you, Chief Justice.
All right, well, we'll study this, but it's all, we can read Bentman again. Thank you. Questions from anybody? All right, thank you very much for your time. Good argument.
Okay, thank you very much. Have a good day.
5-minute break and do our last case.
The next argument is Commonwealth of Pennsylvania versus Gregory Jordan. Representing Mr. Jordan is Mr. Brandon Ging. Representing the Commonwealth is Mr. Kevin McCarthy.
This case pertains to the allegedly inconsistent verdicts reached at a consolidated bench and jury trial requested by a criminal defendant. The jury acquitted the defendant on all charges before it. The trial court rendered a guilty verdict on the related charges. On appeal, the Superior Court held that inconsistent verdicts are permissible in consolidated jury bench trials, and that the two separate fact finders are not bound by the factual or credibility determination made by the other. The appellant challenges the Superior Court's conclusion, argues that it's inconsistent with the Superior Court's recent decision in Commonwealth versus Rankin, which held that inconsistent verdicts are barred by collateral estoppel if the jury's verdict necessarily relied upon the same facts employed by the trial judge. This court granted allowance of appeal in the matter to examine the permissibility of inconsistent verdicts in a consolidated jury and bench trial. Mr. Ging, please feel free to proceed.
Thank you, Your Honor. Good afternoon, and may it please the court and Mr. McCarthy. My name is Brandon Ging from the Allegheny County Public Defender's Office, and I represent Gregory Jordan in this matter. It's my honor to be here for a second time today. As you indicated, the issue here centers around the doctrine of criminal collateral estoppel. That argument can be broken down into three parts as I raise it in my brief. First, that the doctrine's traditional requirements of two actions was satisfied in this case because of unique circumstances involved. Second, that criminal collateral estoppel can and should apply within the same trial, which is what the Superior Court held in Commonwealth versus Rankin. As it happens, I was appellate counsel in that matter. And third, that the doctrine has been constitutionalized under the double jeopardy clause. And it's our contention that it has to be expanded beyond that clause because it fails to account for society's and the criminal justice system's changing needs and attitudes. And that includes what is now a rather commonplace practice of consolidated jury bench trials. In simplistic terms, collateral estoppel means when an issue of ultimate fact has been determined by a valid and final judgment, that issue cannot be litigated again between the same parties in a future lawsuit. The preeminent case in that matter is the U.S. Supreme Court's decision in Ash versus Swenson. That case is where the Supreme Court defined really what collateral estoppel is. That in criminal cases, it cannot be applied with hyper-technical or an archaic approach of a pleading book, but it requires realism and rationality. The courts have to look at the record of the prior proceedings, take into account the evidence, the charges, any other relevant matter to determine whether a rational jury could have grounded its verdict upon any issue other than that which the defendant seeks to foreclose further review. This honorable court's preeminent case is Commonwealth versus States. That looked at criminal collateral estoppel under the lens of double jeopardy, and it synthesized that pronouncement in Ash, and it came up with three elements. First, whether the issues are sufficiently similar and sufficiently material in both actions to invoke the doctrine. Second, an examination of the record of the prior case to decide whether the issue was in fact litigated. And third, examining the record and everything else to determine whether that issue was necessarily decided in the defendant's favor. So that's a short synopsis of what criminal collateral estoppel is. My first argument in this matter is that those traditional requirements were met here. The Superior Court made the finding that this was in fact an inconsistent verdict, and I don't disagree with that. Ultimately, I don't even think that's in dispute, to be blunt. I apologize, my office phone rang. Really what the hiccup was the trial procedure utilized here, and that was the consolidated jury bench trial. I'm not at all trying to suggest that that isn't what the parties intended to happen. But the problem is my client didn't waive his right to the jury trial on the severed charges until after the jury trial had been resolved and the jury came back with the not guilty verdicts.
Counsel,
Yes.
so if I understand you correct, in essence, you're hanging your hat on the fact that your position is the second subsequent proceeding is caused by the waiver colloquy on the summary offense. Yes?
Yes, but just to clarify, they weren't summary offenses. I believe they were felonies.
I apologize. You're right. You're absolutely. I stand correct. Yet my understanding, there was no additional evidence introduced. It was the form when the judge realized he had not provided it. Your client already conceded and agreed to a dual matter. And literally after he was colloquied, there was a verdict of guilty entered. So I guess what I'm trying to get at is you're asking us to indicate that the definition of a second subsequent proceeding commences upon a colloquy as opposed to an introduction of subsequent evidence that was not included in a first trial.
Generally speaking, I would say yes. In that regard, I'll be blunt. I was trying to find cases that address this scenario, and I wasn't finding much. The closest I found was Commonwealth versus Dowling. That's a case by this court in 2008. And the issue there dealt with a withdrawal of a jury trial waiver, because it says it can occur, quote, any time before the commencement of trial. And the issue there is how to interpret when does a trial begin. The defendant wanted it to be interpreted when jeopardy attaches. But this court held that, looking to Rule 600 line of cases, that, quote, the commencement of trial should be marked by a substantive rather than a pro forma event. My argument with regard to what happened here is, again, there's no dispute. All the parties intended this to be resolved as a consolidated jury bench trial. But what happened was, after the jury trial rendered its verdict, the trial court said, I'd like to take a few days before I announce my own verdict. They came back several days later, and right out of the gate, the judge said, we never colloquied him on his right to a jury trial in this matter. And I think it caught everybody.
But the judge only followed his procedure. What is it, 622? You have 7 days after commencement of a jury trial to come out with another verdict? Is that the rule?
Yes, that's correct. It's 7 days.
So all he did was exercise a procedural aspect, nothing of substance. I guess that's what I'm concerned about.
It was Justice Doherty. It was a she. It was Judge Beth Lazara, I believe.
Oh, okay. Thank you. But the court exercised her judgment to render a verdict 6 days after the jury. So what you're really trying, I guess what I'm trying to get at is, again, you're making this what I see to be a procedural aspect. You're trying to indicate it's substantive for purposes of establishing a second subsequent prosecution, despite the fact that there was no additional testimony other than that which a jury heard. And we already know established case law does permit us to have inconsistent verdicts.
Well, if I could address that in multiple parts. Strictly speaking, there should have been some additional evidence with respect to the severed charge that he was in fact.
Let's look at the facts, Mr.
Sure.
Gibbons. There wasn't.
That's correct.
So that's because we're only, our hands are tied by the facts before us, and I'm trying to find out what your argument or your position is.
Yeah. Again, my first part is that the Superior Court came to the conclusion that this was a consolidated jury bench trial. And my response that that's not factually accurate because of what happened here. My argument, relying on the Commonwealth versus Dowling case, is that the non-jury component cannot start until the defendant is made aware that he actually has a right to a jury trial in the first place. Again, this is the situation where,
Counsel, it's Chief Justice Barrett. I just want to follow up. I don't want to cut you off, Justice Doherty, but you have to argue the issue as you raised it, and correct. You framed it in the aliquotter. And the issue that you framed and you phrased is whether the Superior Court panel erred as a matter of law in concluding inconsistent verdicts are always permissible. So there was nothing about this procedural irregularity. We don't like it, but you waived the waiver, if you will. You didn't bring that issue to us.
I'll move on, Chief Justice. I'll move on. My second argument is more along the Rankin line of cases. And again, I was counsel in that matter. And Rankin had a consolidated jury bench trial. He was charged with fleeing and eluding and a number of summary traffic offenses flowing from that. The only issue in dispute at trial was who was the identity of the driver. The jury came back and found him not guilty, a logical conclusion that he was not the driver. The trial court found him guilty of the attendant summary traffic offenses, ultimately disagreeing with the jury's verdict and concluding that he was the driver. I argued criminal collateral estoppel, and the Superior Court agreed with me and reversed the summary convictions. They didn't find the fact that this was...
Stop too. Did the trial judge's finding stop the jury, or the jury's finding stop the trial court?
I'm sorry, Your Honor. Could you repeat that, please?
Yeah, which entity stopped the other in Rankin? Did the jury stop the trial judge, or did the trial judge stop the jury, and why?
The trial court was precluded in light of the initial jury verdict. I hope that answers your question correctly.
Why was that in the simultaneous trial?
In that case, again, the Superior Court found that it wasn't fatal to its analysis that this was one proceeding. And I think it's because they looked to what Ash instructs, that you have to look at these types of issues with rationality and realism, not hyper-technicalities. And in that case, they applied what I would call the more substantive issues. Again, was the issue put before both fact finders? In the first proceeding, was it litigated? And thirdly, was it decided in the defendant's favor? And in that case, the Superior Court found rather easily, of course, the issue of the identity of the driver was argued at the jury trial.
I'm sorry, go ahead and finish your answer.
The jury concluded that he wasn't the driver, and therefore that collateral estoppel applied. They weren't hung up on the idea of one proceeding. Now, that being said, I recognize that double jeopardy, strictly speaking, requires a first and a second proceeding. And that kind of brings me into my third issue.
We'll have to look at Rankin hard.
Before you go to your third issue, this is Justice Todd. I had a follow-up question. Maybe I'm missing something, and maybe you're just 3 or 4 steps beyond where I am, but isn't the foundational or a foundational question, since we allow in Pennsylvania inconsistent jury verdicts when there are multiple counts, why shouldn't we allow an inconsistent verdict in this setting?
My response to that is certainly when a jury sits as alone, whether it be a jury or a non-jury, when it's one fact finder and that fact finder wants to render verdicts that are inconsistent with other aspects of its own finding, it's perplexing, but it's...
But we allow it. We allow it.
Yes, you're willing to tolerate it. But the problem here is one fact finder nullified the verdict of another fact finder. And that is where I begin to start having issues. I hope that my brief is thorough enough in explaining that, we obviously regard juries with the utmost respect in their verdicts, both at the federal level and in Pennsylvania. And we regard that, when a jury reaches these perplexing, inconsistent verdicts, they're just exercising, some lenity and things along those lines. But in this particular case, it was the judge who rendered an inconsistent verdict. If you look historically, the right to a jury trial was the preferred method of disposing of facts in criminal cases. Again, I'm not trying to undercut the value of non-jury trials, but the state's case, this court had an opportunity, and it acknowledged that of all the case law that talks about criminal collateral estoppel, nothing really addresses these consolidated jury bench trials. It didn't approve or disapprove of the procedure, but it did specifically note that it complicates things. And I think that this is the hallmark of that.
Well, it seems to me if you are going to prevail, we have to be persuaded that these were 2 separate proceedings, not an agreed upon consolidated jury and bench trial.
Right now, I would reluctantly say that the case law would regard these as one proceeding. The fact that there's the evidence is introduced once before two different fact finders. That seems to be enough for courts to conclude that these are one proceeding. I'm personally not willing to go that far, but that's what the case law says. But
Mr. Ging?
yes.
Could he finish this answer, Chief Justice?
Yeah,
I'm
I
sorry.
thought you were done. Go ahead.
I'm not willing to go that far. I think when you have two different fact finders, it's almost kind of like what I alluded to, assuming this was two different, like these stipulated non-jury trials where you hear the evidence of the suppression hearing and you incorporate it into the jury trial. The fact that there's two fact finders, but the evidence is introduced only once, that's for convenient purposes, and I can understand why. But I still think the fact that there's two different fact finders, it's appropriate to consider these as two proceedings. And in fact, I think the state's court said as much. I believe that they actually quoted that, and they said, here, two proceedings were jointly held before two separate fact finders, end quote. So if you take that at face value, it seems the state court, at least in some sense, was regarding these as two proceedings.
But that's an entirely different case. That's an entirely different case, Mr. Ging.
Yes.
I mean, that's a case where the jury deadlocked, and the question was whether he could be retried. You're talking about two entirely different cases. This case was one case, and perhaps the reason you didn't find any cases in our court is because it happens all the time, and you're just maybe the first one to complain about it. But there was only one fact finding here. You elected, you consented to a bench trial on the disorderly conduct and the two felons persons not to possess, I guess.
That's correct.
So you consented to go that way, and that's a consent to have the trial judge make her own judgment, including credibility findings. And I'm at a loss to understand where you're coming from. Let me ask you this. Suppose we agreed with you. And we validate your position here. Doesn't that create some sort of breakneck race in these scenarios between the judge and the jury to reach a verdict first, because whoever reaches the verdict first trumps the other one, and the other one can just go home? And if that's the case, then what have we done to the entire deliberative process here?
Well, first and foremost, I do agree with you that states is nearly on all points different from what we're dealing with here. I acknowledge that. And I was contemplating that question, who goes first in terms of announcing a verdict? And I think, again, because of the value and the respect that we place on the jury verdict, I think it's appropriate for the jury to go first in situations like this. And then ultimately the judge can render its verdict subsequent. And I hope I'm not coming across acting as though it's easy to establish criminal collateral estoppel. I don't think that at all. I actually think the more complex a case is, it becomes very difficult to really argue that an issue was litigated. It was actually decided by the first fact finder. I don't think it's an easy argument to make, but I think that if criminal collateral estoppel, it's a common law doctrine. It was incorporated through double jeopardy, but I don't think it's limited to double jeopardy. I think that if you look at its common law roots and its due process roots, it's about fairness. I think that the double jeopardy clause is pretty strict and narrow, and rightfully so. But I think that this doctrine needs to come a little full circle and appreciate that we now have these proceedings, these consolidated jury bench trials, that at the time this doctrine was constitutionalized, I would venture to say that the court never could have fathomed that possibility.
Mr. Ging?
Yes.
Chief Justice Berman, we're getting to the end of this. Let me just ask you, if your client had exercised his constitutional right to submit all of this to a jury, and you would have had the identical verdict, wherever the trial court found him guilty, he's guilty. Wherever the jury found him not guilty, he's not guilty. That would be unfathomable to him and to you. But you're stuck with that as an inconsistent verdict from one tribunal, the jury. Correct or incorrect?
That's difficult to answer, to be honest with you.
I think you're stuck with it. I think that's what a tremendous body of Pennsylvania law says. And as you can switch places with me. It's a matter of lenity. They found him guilty of some of the less serious charges and not guilty of some of the more chilling charges. So they exercise the jury's inherent right of lenity, of compassion, etc. But the key to the question, which I guess I answered and you didn't, is there's no distinction between that case, the jury deciding all these charges inconsistently, and this case, where the jury found one thing and the trial judge in a simultaneous proceeding, where all involved agreed to bifurcate who would hear what, decided the other thing. Aren't they exactly the same?
I don't believe they are. As I indicated before, when one fact finder chooses to be inconsistent with itself, you scratch your head about it, but you're willing to stomach it to a degree. But when another fact finder nullifies another fact finder's verdict, that one's, for me at least, I have difficulty swallowing that one, especially because if you don't find that the doctrine of clinical trials, what's the value in a defendant having a consolidated jury bench trial? You're going to foreclose the opportunity to ever make this argument. You may not win it if you have a subsequent jury trial or a stipulated non-jury trial, but at least you have the opportunity to try to make it.
Your client did what your client did with his counsel because there were certain facts he didn't want before the jury. That's why these things happen. All right. Any questions from anyone else? Anything you want to say briefly in conclusion?
No, Your Honors. I appreciate your time. Thank you very much.
As several of Your Honors have already noted, this case is really about inconsistent verdicts more than collateral estoppel, whether or not the court will continue to allow inconsistent verdicts between two separate fact finders in what I would argue was a single proceeding. There was one trial. As Your Honors noted, there was no additional evidence presented subsequent to the jury's rendering its verdict. The proceeding that occurred 6 days later was only the jury trial waiver that, for whatever reason, all parties, including the trial judge, failed to recognize before the trial began. But when that issue was raised, there was a sidebar. Counsel discussed it with the trial court. At the conclusion of that, there was a jury trial waiver, which was executed by the defendant. The court found it to be knowing, voluntary, and intelligently given, and then the court rendered its verdict. This was one trial before two fact finders, which is why States is not applicable. States, as I believe Justice Weck noted, was where there was a hung jury. And after the jury was sent out to deliberate, Judge Colville at the time rendered his verdict on summary charges. The jury came back hung, and before the trial could be relitigated, there was a request by counsel for the court to render findings of fact, which Judge Colville did. So it was a unique situation of the court rendering specific findings of fact. And on that basis, this court found that collateral estoppel precluded relitigation of the issue of who was the driver of the vehicle. That's what precluded the trial there. No such thing happened here. And contrary to Mr. Gink's statements, the trial judge did not nullify the jury's verdict when she rendered her own verdict on the charges that were directed to her. She didn't reinstitute the charges. There were no convictions entered. The defendant was acquitted by the jury and discharged on all of those charges. So there was no nullification. The defendant himself elected to have these charges tried non-jury. And as so often happens in our courts, defendants are required to elect between two evils all the time. And they make that knowingly, intelligently, we hope, with counsel's advice, and they suffer the consequences, good or bad. And that's what happened here. The trial judge made her own findings of credibility of this victim. The jury dismissed her testimony. The trial judge credited it. That was her right as the fact finder.
Counsel, Chief Justice Baird, what about ranking? Is it distinguishable, or do we have to overrule the Superior Court in that matter?
I submit you should overrule Rankin. It is absolutely wrong. First, it fails to recognize the Superior Court's own precedent of 2 published opinions, which it had no authority to overrule. It ignored them, essentially, but it should not have. It did not apply, or rather, it also applied states without giving any discussion as to why states should be applicable to a situation with a single trial with 2 fact finders as opposed to a hung jury in a subsequent prosecution. So it is absolutely wrong. If the court has no other questions, I will submit on my brief.
You're getting away awfully easily. No questions from anyone? All right, thank you, Mr. McCarthy.
You're welcome. Thank you, Your Honors.
We're going to stand in recess for 5 to 7 or 8 minutes. We have a technical problem with one of our audio feeds, which our technical people will work with that. Justice will come back at that juncture. Just the court.
Chief Justice, it's Justice Todd. May I say one thing? I just wanted to point out that the camaraderie and collegiality exhibited by Mr. Ging and Mr. McCarthy are a great example of the civility we seek to achieve among our bench and bar. So I wanted to commend them for that.
Thank you, Your Honor.
Agreed.